Good afternoon. The 14B District Court is now in session. I am Elaine Washington, and I'm the judge that will be presiding over the session. I want to apologize to counsel and to the parties, as I am the only judicial officer in the building this week, and so I was not being derelict. I was actually handling criminal matters on a separate Zoom, and this is as soon as I could get over to this particular meeting. I was doing arraignments. Okay. All right, the court will call the cases of Kyle Klosik versus Alicia Adzima, case number 20C-1495, and Alicia Adzima versus Kyle Klosik, case number 21C-0609G.
Good, Your Honor. Joe Lloyd appearing on behalf of the defendant in the landlord-tenant matter.
Your Honor, George Soteropoulos appearing on behalf of Kyle Klosik in the civil matter, the 0609G case, Your Honor.
Thank you.
Good afternoon, Your Honor. Brandon Biggs on behalf of Kyle Klosik in the eviction proceeding, Your Honor.
All right, thank you. All right, we were here a few weeks back, and I had this matter reset for today's date in order for the parties to have an opportunity to come up to speed on where we were, and then we're back for a status conference to try to figure out what's going on with these cases. Is that correct?
Yes, Your Honor.
All right. So I know, Mr. Lloyd, you were going to look into some things and be able to tell us where we are with respect to your matter, which is the 20C-1495.
Yes, Your Honor. With that, I believe, as the court knows, there, let's see, Judge Pope had put a stay in place, and we had talked about at the last hearing that was pending a decision by Judge O'Brien to lift it or not. I don't know that she has or has not. I believe she has not. And what I would, if I were sort of thinking about the procedures in this court on that case, the next thing that we might see is a motion either here or there to lift the stay, and then we could argue it or not. If the stay is lifted, I think we had not filed our responsive pleadings. Our first responsive pleading was a motion for stay, and then we would could go ahead and treat it as an ordinary landlord-tenant case if it comes that far.
I think I agree with your assessment. Mr. Biggs, do you plan to file anything in this case, or are we just going to put it back in stay status?
No, Your Honor, we have, and I've been working with brother counsel, Mr. Soteropoulos, about because obviously he's been dealing with the case with Judge O'Brien, but I tend to agree that if it is the will of this court that we need a more definitive statement, because as we talked about at our last conference, it's still our position that the actions taken by Judge O'Brien, albeit missing the quote unquote magic language that seems to be asked for, that was a final judgment that addressed the House explicitly, and we don't believe that it should be required. But if it is, then I agree the next step would in fact be to have Judge O'Brien confirm that was indeed her intention, that the stay no longer be in place, even though the property was already dealt with and a time frame for Ms. Adzima was already put in place in her last order.
And Your Honor, I'm sorry, Your Honor, but being the family law attorney in that case, and I know the court heard from me when we previously met at the end of June, and I thought it was the court's position that the intent was clear through the consent order that was signed by Ms. Adzima, that was negotiated between the parties, and the fact that she did have counsel, that she agreed to be out 3 to 6 months. And there was further discussion when the homeowners association attorney was here, that a bond request was made, that she needed to post a bond in that. if I misunderstood the court, I apologize. I didn't know the court. There was no mention, as far as I remember, that I needed to petition Judge O'Brien to lift the stay since the consent order was freely signed. And she agreed to be out within 3 to 6 months.
My understanding and what I recall, I'm not looking at a transcript, obviously, is that I was very clear that I believe that the consent order did say that she needed to be out based on her own agreement to be out. However, the order also was silent as to the lifting of the stay. And I thought I was fairly clear that the parties need to either file a motion to get the stay lifted or whatever was necessary, either at that level, the family court level, or this court, in order to have an argument and some type of ruling made on that if you wanted the stay lifted. That was my last understanding of that part of the case. And then I know that Mr. Lloyd wanted to come up to speed on the matter as well. So that's why we were back here. And I was hoping that we would have some movement. I do note that in case number 21C0609, Ms. Adzima has filed a motion to amend the complaint and to remove this case to Washtenaw County. This is a general civil matter that does not meet the jurisdiction for $25,000 or more, at least it's not alleged at this time. So I don't know if you've seen that, but apparently this was filed back on May 19th. I don't know why it was not in the file last time I saw this, but it is in the file now. So I'm not sure if so I thought last time we were here, I found documentation that showed that Mr. Lloyd was representing her in all these cases.
I believe, Your Honor, that I am not representing her, certainly in the personal injury case. I can do a formal request to withdraw. I've never done personal injury work. I'm a little old to start, and but if there's something that suggests I'm the attorney of record, I'll file a motion to withdraw and I'll circulate it for signature.
I'm looking again to determine that. I don't see you in that one, actually.
My memory isn't altogether failing, and thank you.
Having said that, Ms. Adzima has not appeared here today. Ms. Adzima.
Your Honor, I see her on my screen. I mean,
a name on my screen. I see
the name is here.
Ms. Adzima, please turn on your screen.
We'll figure it out. Your Honor, there we are.
Please state your name for the record, ma'am. You're muted.
You're muted.
Alicia Marie Adzima.
All right, ma'am.
Thank you, Your Honor.
All right. Apparently, Ms. Adzima called the court today speaking to staff and questioning some decisions that Judge Pope made over a year ago in some of these cases, and also making accusations that apparently someone's switching out the actual case numbers on the pleadings, and that the court is issuing bad notices.
Your Honor, I will apologize on behalf of my client, even if I'm not in this case. I mean, we certainly understand the confusion of the multiplicity of cases, but I know of nothing, and I've not seen anything or brought anything to Ms. Adzima's attention that shows anything other than perhaps a little confusion, and we've always worked it out in the end. my apologies to the court and the court staff, and on behalf of myself, if needed, on behalf of her, also, Your Honor.
Thank you.
Apologies as well.
All right. As to the cases that are before the court today, it appears that we need some additional time, at least in the landlord-tenant case, in order to file the proper motions to stay or lift the stay. Is that correct?
I
That
believe
is correct, Your Honor, and I apologize for my misunderstanding, and I will make sure to get that motion filed forthwith.
And based on the fact that Ms. Adzima has filed a motion to amend the complaint and to remove the case to the Washington County Circuit Court, I believe that there should be some response to that motion, and it needs to be.
Your Honor, I do not have a copy of that motion. I apologize. I don't know.
I'm reviewing the proof of service here. The proof of service indicates that she and her pro per status certifies on a penalty of perjury that she served a copy of the motion on Mr. George Soteropoulos by first class mail and by email to the address as stated in the caption. So she's saying she sent it to you at your 1310 South Main Street address.
I don't have a hard copy of that. I'll review my email, but I don't have a hard copy of that motion, Your Honor.
Your Honor, I do have a receipt from USPS that I did ship that to George Soteropoulos. I do have that receipt handy if you need me to show it to you right now.
we'll also see that he gets another copy, Your Honor. I mean, I don't
Right.
think this is about finger pointing. It's about everybody having a chance to plead. So
All right, and so you can proceed in one of two ways. I can allow the parties to notice it back up onto the docket on a date wherein it can be heard, or I can set a date and have everyone prepared to be back here to address those two motions. And I hear crickets.
no, Your Honor. What I would suggest, why don't you let us work it out? I mean, at some point, we all have calendars to deal with, and we'll get it up pretty promptly. I think if Mr. Soteropoulos and Mr. Biggs coordinate a little bit, I'll move stuff around as needed, and I think Ms. Adzima can be available. And we'll see what we can solve without needing to actually argue it. I mean, I don't know what's actually contested and what isn't. So
That sounds great in theory. But in practice, I often lose track of files that way. So I will set a scenario that allows both of those things to happen. I think we're back here anyway on case number 20C 1495 on August 26th.
That's correct.
2:30. So I will set the 21C 0609G over for that same date and time. If there are any motions that you have that need to be filed and heard prior to then please do so, but I'll set this other case over to that same date. Okay.
Your Honor, I guess I'll just remind Brother Counsel and the court, the last time we were here, the reason we set it for August 26th is that I wasn't going to be here August 10th through the 24th. So if there are any motions that are going to be scheduled, I just ask that they either be set before August 10th or after or on the 26th, if possible.
thank you for the reminder.
All right, I'll set this for a status conference on that date.
Thank you.
Thank you.
All right, thank you. Sorry for the wait.
Thank you, Your Honor. It's always entertaining.
Busy time.
It's
Your
not
Honor,
the word from my court, but I
Well, no, this is the life we've chosen.
yes, it is. Thank you. I will
Okay.
Thank
be
you, Your
here
Honor.
for the
Bye-bye.
22nd.
hey, Your Honor.
Thank you, Your Honor.
Bye-bye. Guess I can't leave, can I? Mhm.
Okay, so I have your 230, which is the Forest Health versus, yep,
Let's go.
I'm letting them in right now. I don't have a defendant, I have both counsel.
Court will call the case of Forest Health Services versus Angela LePan, case number 21C030385.
Good morning, good afternoon, Your Honor. I suspected your day has been like my day. It's just been busy, busy, busy.
It has been, and Magistrate Nelson is out, and so I'm doing both the arraignments and my regular docket today, and that's why we're running a little behind. So
I'm surprised you're even through anything, given that I know what those dockets look like. Well, as I said, Stuart Collins on behalf of the plaintiff.
hello.
Good afternoon, Your Honor. Patrick Carmody appearing on behalf of the defendant, Angela LePan.
Good afternoon, Mr. Carmody. How are you?
I am here.
All right, this is the defendant's motion to set aside the default judgment in this matter.
Yes, Your Honor. As we set forth in our motion and the affidavit, Ms. LePan indicates that she was not served, did not receive any notice of any lawsuit. Looking at the time that was put on the affidavit that the process server was using, it appears that was the time period when she was in Cabot, Arkansas. Ms. LePan's father died October of last year. And since that time, she has been visiting with other family members and assisting them down at Cabot, Arkansas. As a matter of fact, that's where she is right now. But she did not have notice of this lawsuit. When she received a copy of the judgment, she contacted me and I went over it with her. We submitted her affidavit. I believe that it's appropriate for the court to set aside the default judgment for non-service and let us move forward and see if we can resolve it. I would also indicate that there is a valid defense in regards to this, is that she had health insurance. The injury that she was receiving medical attention for was a work-related injury at the University of Michigan Hospital. She had health insurance through them. She also has a workers' compensation claim, and she has provided the information regarding the doctors to her workers' compensation attorney. So there's no prejudice, as I see it, to them. And so therefore I'd ask the court to set aside the default.
And I understand that she's saying she did not receive it. However, they're indicating that they did tack and mail it to her. Was someone else staying at her address at that time?
As I understand it, her son was there part of the time, but whether he was there at the times that they made the postings or things like that, I don't know. I know that the affidavit indicated that the person talked to neighbors and they had no idea about her. She's lived there for 15 years. She knows all of her neighbors, so she does not believe that they would have said that. And if they had actually talked to them, they would have probably known where she had gone because she asked them to watch the house. So again, she didn't have any notice or knowledge of the lawsuit. She has a valid defense, and I would ask the court to set aside the default.
Mr. Collins.
Your Honor, there is no good cause. There is no meritorious defense. Firstly, in addressing good cause, I appreciate that Ms. LePan may or may not have been at a residence at the time, but we did the process server made several attempts, wasn't able to serve there, clearly because she probably was out of town, and that's not a fault of mine or the process server. We did a postal verification, which verified that indeed she did live at the address. The court signed an order for alternate service based on those things. We sent, in accordance with the alternate service order, both tacking and mailing. Default judgment was set in there to the court, and there was no response. Even so, Mr. Carmody claims that she has health insurance. That is not a defense. I don't know how many times I have to go through this with attorneys or courts, but the fact that she had health insurance is not a defense. The third-party statute in Michigan makes it very clear that unless there is a contract that specifically says that the defendant was going to get services directly from the hospital, and that particular hospital was directly going to get paid from the insurance company, and they all three agreed to that, she is ultimately liable. It is up to her to file a suit against the insurance company if indeed the insurance company is going to pay anything. That's their contract. We're not in privity of contract with this insurance carrier, whoever it may be. Similar, if she's got a workman's comp claim, she needs to take care of it through workman's comp. We are out of that equation. Consequently, Your Honor, this motion for, needs to be denied, and we'd ask that we be permitted to move to post-judgment remedies.
All right, Mr. Carmody, given that the responses, and I believe we've gone through this before, and the law is that having insurance is not a defense. Can you, so that's the meritorious defense issue, and as you know, it's a two-pronged test. So even if I believe that there was good cause, which I'm not saying I do, what is your response to that with respect to the insurance?
Your Honor, all I can say is that she has insurance and she believes, she also indicates she's never been billed on any of this stuff. And again, those are facts that we would have to address. I believe the fact that she did not have any knowledge of pendency does allow the court to set it aside, but it's certainly within the court's discretion, and the court will do what it believes is appropriate.
Thank you, I appreciate that. Given that the court has concerns about the meritorious defense in this particular case, the court is not going to set aside the default in this case. The default will stand. One second. That's correct. The motion is denied. And I presume you'll present an order to that effect, Mr. Carmody.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
You're welcome. Danita.
Yeah, I don't think he's coming. That's why his cell phone is up top. So you might have to call him.
No, I'm looking at this Danita number that's in there. Is that on that?
Yeah, Danita will. She's the one who's on.
She's saying she didn't get it?
She didn't get the motion for summary disposition. That's why she didn't.
Oh, I see. It's a.
Are we talking about the Cannon case?
No, I'm not. No, I'm not.
Because we still don't have the third part. We sent in a motion for alternate services, second summons on that one. There's not a lot we can do in that case. There's a default against the other one, so I don't know if you wanted to quickly deal with that.
All right. The court will call the case of Anointed Cuts LLC versus William Martinez. And there's a third party case of Anointed Cuts and Gregory Cannon versus William Martinez and Darlene Fuller. Case number 20C2339.
Good afternoon again, Your Honor. Stuart Collis on behalf of Mr. Cannon gosh, what's his company called? Defendant and third-party plaintiff. Okay, we'll go that way. Your Honor, in this case, we have defaults now against the plaintiff, counter-defendant, and third-party defendant, William Martinez. But we still have not gotten this Fuller served. I believe there's a motion for second summons and alternate service or at least second summons to extend it on Ms. Fuller. We're just, if we could adjourn this out so that hopefully we could still get her in here, that would be great.
All right, I'm gonna adjourn it out. 60 days.
All right.
What's the problem with getting her served?
For whatever reason, process server can't seem to serve her. We have not yet. I can't remember if we do or don't have the postal verification yet back from Detroit where she lives. But I know she's a real estate agent, so she's always on the road. So as far as I could tell.
October 28th, 2021 at anytime, 2 p.m.
All right. Hopefully we'll have it done before then.
Thank you very much.
Thank you, Your Honor. Have a great day.
You too. Bye-bye. Yes. Yes. Court will call the case of Midland Credit Management versus Denita Wells, case number 20C2455 GC.
Good afternoon, Your Honor. Preston Nate, P77884, appearing for Midland.
Thank you, Mr. Nate, for showing up.
Yeah.
The fact of the matter is this case was supposed to have all of the court dates canceled, but the court had set on May 13th a court date for today's date at 2 p.m. There was, at that time on May 13th, the court gave a motion cutoff notice for all motions to be heard by July 15th. And you showed up here on July 15th, and the motion was heard for summary disposition. And at that time, the defendant failed to appear. The court granted your motion based on her failure to appear and actually based on the actual merits of the argument, and told you to provide the court with an order under the 7-day rule. The problem is we haven't received the order yet, and therefore she called the court to indicate that she had not, I believe she spoke with the clerks, indicating she had not received the motion, and they advised her to come in today. And so as a result, because we have no order and because she is indicating she did not receive the motion, the court case was called. All right, Ms. Wells?
Yes.
So I have a very thick motion here that this court heard back on July 15th when I gave both of you the notice to be present. In addition to that, I have a proof of service from Miss Allison Sheldon indicating that you were served at your address on Buick with this on June 16th.
I didn't receive that. Did it just show my signature on it? I didn't receive it.
You don't have to sign for it, ma'am. It gets placed into the mail. That is proper service.
I didn't receive it, unfortunately. There's other people who live here and I didn't receive that mail.
Mr. Nate.
Well, I mean, I do understand the frustration, of course, but we did mail a copy to the what seems to be the correct address on Buick Drive or Buick Avenue. I'm not really sure, you know, we can only do so much to get the motion to where it needs to go. It sounds like it did get to where it needed to go. I don't know what happened to it after it got there. Sounds like she may not have seen it or not, but I guess based on the merits of the case, we still would like the judgment to be granted, if at all possible. I don't know if there's an argument on the merits of the case or, you know, a statement of fact that would need to be presented at trial that would bar us from getting a judgment under the motion for summary disposition. But at this time, we would still ask the court to grant that judgment.
I understand. I think she still hasn't received it. Is that correct?
No, what was it exactly?
It's called a motion for summary disposition, ma'am. That's part of the problem when people don't get counsel to represent them. They don't understand what's going on. So a motion for summary disposition says that they are entitled to receive a judgment based on the actual facts of the case as they stand, and that you don't have a defense to it. So that's what the motion is based on. There's
right.
Here.
No, I didn't receive that. I didn't receive that. The only thing that I did receive was just a copy of.
Ma'am,
okay.
I'm past whether you received it or not. Okay. Now I'm trying to find out from you if, after you said you didn't receive it then, have you gotten it since that time? Do you have it in your possession?
No, Your Honor.
All right. Because she's in pro per, Mr. Nate, I want her to at least get a copy of this so she can see what's going on.
Sure.
Can you please send that to her?
Yeah, I was gonna say, we can remail it to her. That is fine.
My question is that I had reached out to their company and they told me that they sold my account to a different entity, and I was trying to figure out if this is correct.
You may respond, Mr. Nate.
Oh, I was gonna say, yeah, we So Midland is a debt buyer, so they did purchase the debt. We can send, along with the statements, we can send that chain of title so she knows that this is correct. And so Stinger and Stinger is representing Midland Credit Management. So that's why some things say Stinger and Stinger, but it is a file for Midland Credit Management. So we can send that along with the statements as well, just so that I can kind of satisfy her on that front.
So the motion for summary disposition does include along with it a bill of sale, ma'am, that shows that it was sold. And that is something that typically happens with these types of debts. They get sold. It still means that you're liable to the party who's bought it. So it doesn't change the fact that you're liable for it simply because it's being sold.
Okay, I just didn't know that nobody sent me anything to know that it's sold and how much I will be, how much I can pay to settle the bill. I want this to be taken off my credit and get it situated so it won't continue to affect my credit. This is what I'm trying to do.
Mr. Nate, I think you had a couple of courts going in the background according to my staff. Are you able to talk to her in a breakout room today, or do you need to call her later?
No, if she wants to do a breakout room, that is fine.
All right. Ms. Wells, I'll give you a breakout room where you can talk to Mr. Nate and see if the two of you can work this out. Is that what
Okay.
you do, ma'am?
Yes.
All right, we'll give you that, okay? And then
Um,
when you're done, you can come back in here and let me know that if you have something you want to place on the record, okay?
Perfect. Okay.
All right, thank you. All right, recalling the case of McKinley, I'm sorry, wrong file. Midland Credit Management versus Danita Wells, case number 20C2455.
Preston Natigan, P77884, appearing for plaintiff.
Do we have any success in the breakout room?
I think we did. We did come to a number that we were willing to accept. I think Ms. Wells is going to see if she can find the funds to meet that number. It sounds like she may be able to call her office today. She might be able to confirm that. If so, if she's able to pay off the amount that we talked about, then we'll get the case dismissed and get her all the paperwork that she needs. But she might be able to fill you in a little bit better on that. But that's kind of what my understanding was.
All right, Ms. Wells.
Yes, I'm trying to I'm gonna go to the bank and make some transfers and get that situated. I need a letter stating that the balance is paid to zero balance once I make that payment, sent via to email or to a fax number if possible.
All right.
Yeah, either one is fine. Like I said, the funds will need to clear. So if you make the payment today, it might be tomorrow that we get the letter out to you, but we should be able to do that pretty quick.
What's the total amount we're talking about here?
So the total balance on the file was $3,825.40. We have talked about a settlement amount of $2,650 that she can pay.
And then you'll do a dismissal?
Yep. Once those funds clear, we'll get the dismissal processed, and then she would like a zero balance letter, which we normally would send her out anyway, but we can email that to get it to her a little bit faster, or fax, or whatever she would like to do.
All right, I'm gonna put this on for entry of order in this case. Either way, entry of order date. I'm gonna give you guys about 30 days to make that happen. So that'll put us.
Is there any way that they'll be able to remove that off my credit to say that there was a dispute?
I'll have to check with our client, Midland. Some of our clients are able to remove the whole thing. Some of them just get it updated to, either way, I think they do get it updated for you. If it's not completely removed, it will be updated to show that it's been paid. But getting a letter from our office would probably be a little faster. I'm not sure how fast, Midland is able to do that on their end, but.
The 5 things, this is just an EO, so. Right, do put it at that time. August 26, 2021 at 2 p.m. for entry of order. So either way, this, I'm gonna have a dismissal by that time, or the MSD should, the court's ruling with respect to the MSD should come over and be addressed prior to then, okay?
Yeah, that sounds good.
All right.
So so how long are you gonna put the notes into the company to say that amount? It should take about an hour or so.
Well, I'm gonna note your file as soon as we're done here. So you can call anytime. Just give me about 5 or 10 minutes just to make sure I get the notes in, so that whoever you do talk to in our office, they'll be able to see that we had talked about the 2650 and kind of help you out. But that won't take long at all. So just give me about 5 or 10 minutes, and then anytime after that, you're just fine to call.
All right, thank you both for working this out. I appreciate it.
You bet. Thank you, I appreciate it. Thanks as well.
Bye-bye.
Bye.
I did already.
Oh, you already. You want me to remove Ms. Danita?
She'll remove herself. Ms. Kazari, I don't think I've ever seen you that much of close.
I'm in my.
Messing with you. You know, I gotta have some fun in my life.
I know, I can't figure out, this is a new configuration. I'm in my office.
Oh, okay, I see. That explains it. You're like, hey, what looks best?
Your Honor, is Mr. Moore present in person or anything?
He's not present in person, no. It is just 8:40. I think this was scheduled for 3:30, so I'm gonna give him some additional time to show.
Okay.
Did I say 8:40? It's been a long day. It feels like it's 8:40. I meant it's just 3:40. Ms. Wells, your matter is all done. You can exit the courtroom. I'll come back in about 5 minutes to see if he's present. Okay, I'm gonna go in recess. The 14B District Court is now back in session. My name is Elaine Washington, and I'm the judge that will continue to preside over this session. Court will call the case of McKinley Inc. Aspen Chase versus James Moore, case number 21C 1438 LT.
Good afternoon, Your Honor. Parissa Gazari appearing on behalf of plaintiff. Your Honor, I do want to state, I don't know if Mr. Moore is present in person. I don't see him on the screen. I did have a conversation with him yesterday via phone. The reason I'm telling this to the court is because we discussed a COD. And my client emailed a copy to him, and a copy was also tagged on his door. I've tried to call him 3 or 4 times today, and his mailbox is full and he's not answering his phone. So I don't know what the court is inclined to do today. I would be willing, if you remember at the last hearing, he didn't appear, but his nephew, I believe, appeared. Yeah, so Your Honor, I'd be willing to, if we want to adjourn this for maybe a week and see if he shows up, see if we can get that COD signed and get the case resolved. Otherwise, I think we're going to proceed with a default judgment. At least that's what we'd be requesting.
All right. To address your issues, I'll try to start in reverse. Actually, the first issue that you brought up, which was whether he's in the courtroom. He is not present in the courtroom here today. He is not present here on the virtual call either. The court is glad to know that he has been in communication with you and that there seems to be some type of resolution that is in the works at least. The last time that we had court prior to this, I do have a very vivid recollection of this case, and that was on June 30th. He was present initially, he showed up, and then he eventually went to sleep. And then he was on the call. His name showed up, but when I called the actual case, his nephew came on the line and tried to advocate on his behalf. And I was explaining to the nephew that he did not have the right to advocate for his uncle because he wasn't an attorney. And there was a long conversation about that. One thing that struck me about this case, and the reason I'm going to make the decision I'm making today, is that the nephew did indicate that his uncle had some severe health concerns. And I remember Mr. Moore, when he came to the first hearing, indicating that his caregiver was apparently causing some of the issues as to why he was in court. And so for those reasons, I'm going to adjourn this matter to see if the parties can actually work it out. Next week, there's a fairly big docket on Thursday, but big is very much relative compared to our Wednesday afternoon. So let me see what I have here.
And then Discover Bank at 2.
What's that, 3?
Tory Thacker and Thacker and Ballard. So that's not going to work. So we've got those 2 at 2, and then we've got JGA Acquisitions, which is a motion under pretrial.
And that's it.
It's this motion for summary disposition. That's at 2:30.
Got 2 of those. I think we have to put it at 3, and I'll start whichever one is ready to go.
Okay.
At that time.
Okay.
All right. I'm going to advise you on the record here, Ms. Gazari, that I'm going to put your matter on at 3 o'clock next week. And if yours is going to be short, I can try to handle it at 3. If not, I'll be handling it whenever I finish the first case that was already set for 3, which is also a landlord-tenant case that was already scheduled for a hearing at that time.
Okay.
But in order to accommodate this particular matter, I'll set it over for that date.
Thank you.
So that is July 29th, 2021 at 3:30 for hearing or COD to be filed.
I'm sorry, Your Honor, did you say 3:30 or 3?
3:30.
3:30.
Wait, what time did I say?
You said 3 the first
Okay,
time.
it's 3. I'm sorry.
That's
You're
great.
right. I wrote down what I had already in my file from this week. So so it's 3 p.m. COD.
Your Honor, and hopefully we'll get in this order to you beforehand.
I hope so. Thank you.
Thank you.
for
Have a good
being
day.
up today. Have a good day.